number 22 CR 2222, State of Ohio versus Dallas James Toll. Present for the States, Prosecuting Attorney Collins, Assistant Prosecutor King. Present on behalf of the defendants, Attorney Jacob Wagner. And you are Dallas Toll?
Yes, sir.
All right. Well, this matter was set for jury trial today, and there was a motion filed on the 23rd of February to continue because Mr. Wagner had indicated he hadn't been able to get in touch with Mr. Toll and he hadn't appeared for appointments, so I set the matter today for a pretrial. The trial was continued to April the 10th. Now, have you had any, is this the first time you've talked to him since the motion?
If I may, sir, yes, we filed this procedurally, if I may, Your Honor. I think at one of the pre-trials, we would have communication problems. You'd order him over to my office to set an appointment. He did come over, set an appointment that day. He didn't make the appointment, but we had discussed over the phone the plea offer from the state. He did contact me yesterday. Again, we went over the plea offer with the state. I think we have a resolution, Your Honor. Again, I've not gone over the form with Mr. Toll. We've gone over the discovery over the phone, but we've not gone over the discovery face-to-face. But I think we do have a resolution, Your Honor.
Well, I'd like to know, Mr. Toll, why you had to call here yesterday and ask about a continuance and talk to my staff instead of talking to your attorney, and then she had to tell you to call him.
Well, I just called here just to make sure it seemed formal.
That you called here and complained about not being able to get in touch with him.
No, I said I called him and left a message, but I didn't get in contact with him, so I called here.
So why call here? How's that something that the court staff's supposed to be concerned about? That's between you and him.
I just wanted.
And you wanted to know about if you were going to get your case continued today.
I didn't know if it had been decided on, so I called for the information.
Yeah, no, it had been decided on. I had just continued your trial, but you were still to be here because, you know, all what's been going on. All right, so we're going to do something today or what?
Your Honor, if he would, I guess if he would like to take a seat, I do have some time after these. If he would like to go over a potential plea form, I have it in my file. But I've not had the opportunity to sit face-to-face with him, Your Honor, and go through the plea form. He knows what the offer is, though.
Well, I think you need to stick around because I had some real concerns about what's going on here. I see some games being played here. I don't like it. So you just have a seat over there and remain here until Mr. Wagner has a chance to talk to you, and then we'll decide what's going to happen.
Yes, sir. I'll tell you what, there, you can sit there. There's a conference.
All right. Where did Mr. Toll go?
I told him to sit in that room so we could go over the plea form, Your Honor.
I want him to sit in the courtroom.
Yes, sir.
Ben, go tell him to sit over there in that corner. All right. Case number 23 CR 13, State of Ohio versus Taryn Deaton. Present for the States, Prosecuting Attorney Collins, Assistant Prosecutor King. Present for the defendant is Jacob Wagner. You're Taryn Deaton.
Yes, sir.
All right. This matter was set for a plea by video, and due to Mr. Deaton's demeanor and court's concern about his situation, the matter was continued until today. And it turns out that I was right because you went in to get tested, and you tested positive for amphetamines and methamphetamines as well as marijuana. So we're here today, as my understanding then, There's going to be a plea. We're going to go forward with the plea.
Yes, sir.
All right. Okay. Defendant is charged with 2 counts of aggravated trafficking of methamphetamine in the vicinity of the school zone, aggravated possession, and theft by deception. The court has received a plea form here, Mr. Deaton. It says you're going to plead guilty to amended count 1 and amended count 3, which would reduce those second degree, well, first and second degree felonies to third degree felonies. This is a 3-page form. Page 3, halfway down the page, there's a sentence that reads, "I enter this plea voluntarily." Signature appears to be Taryn Deaton. Did you sign this document I'm looking at?
Yeah.
When did you sign it?
Within your office?
It's been a while ago, Your Honor.
All right. So when you signed it, did Mr. Wagner go over it with you and explain everything to you first before you signed it?
Yeah.
And you knew when you signed it that it's an agreement to plead guilty, which means there's not going to be a trial. The next step in your case would be a sentencing hearing.
Yes.
And did you feel that you had enough time to fully consider this matter before making that decision?
Yeah.
And did you enter into this agreement to plead guilty voluntarily?
Yeah.
Now, let's see. On page 1, then it says you're pleading guilty to the 2 amended counts, 1 and 3, aggravated trafficking of methamphetamine in violation of section 292503A1, third degree felony. It states that you understand that each of those carry a potential maximum sentence of 36 months in prison, minimum of 9. There's a fine available of up to $10,000 on each count. There's a mandatory fine of $5,000. There's a license suspension of 6 months to 5 years. And prison is presumed. As charged, it's mandatory, but as amended, it would be presumed. And if convicted and sentenced on both of those, you could have those sentences to be ordered to be served consecutively. So that means that the total maximum sentence could be 72 months, total fine $20,000, total mandatory fine $10,000. You understand that?
Yeah.
Are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control from
Yeah.
any other jurisdiction?
I'm on probation
From where?
right here. And I
You mean
mean,
in this-
for this.
Well, no, that's not probation, that's pretrial supervision. So
Oh, okay.
you don't have any felony convictions you're on
No.
probation for. All right. Now, under the law, if you are convicted and sentenced, in this case, to a prison term and serve that prison term, once you complete it, the Adult Parole Authority may, at its option, put you under what's called post-release control supervision for a period of up to 2 years, which means you would be supervised by a parole officer under the terms that they set, because they do that, not the court. And if they determine that you have not complied, then under the law, they can return you to prison to make you serve an additional period of up to 9 months for one violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony, in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that new offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that has to be served consecutively the sentence of the new case. Do you understand that?
Yes.
Now, the law doesn't require me to sentence you to prison, although it's presumed that's the proper sentence. So I could decide that rather than going to prison, you'd be put under community control for a period of up to 5 years in a term set by the court, and you'd be supervised by a probation officer. If during that period of time it was determined that you had failed to comply, then the court could, after a hearing in which you were notified of the allegations and represented by counsel, court could at that time terminate you from probation or community control and then sentence you to 72 months and fine you $20,000. Do you understand that?
Yes, sir.
All right. First count alleges in the indictment that on or about August 2, 2022, in this county you did knowingly sell or offer to sell methamphetamine, Schedule 2, controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the vicinity of the school. And then count 3 alleges on or about August 12, 2022, you knowingly sold or offered to sell methamphetamine in Schedule 2, controlled substance, an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount in the vicinity of the school. Now, I believe then to get to an F3, it has to be amended to make it just a over bulk, less than 5 times bulk
Yes, sir.
in the school zone, and is deleted.
That's correct, Your Honor.
All right. So, do you understand what the amended charges are and what the possible penalties are?
Yeah,
And you understand what you're accused of having done, when, where, and how you're alleged to have done it?
yes,
And have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, possible outcomes of a trial with your attorney?
Have we discussed all the evidence?
yeah,
Are you satisfied with his advice and competence?
yeah,
Are you under the influence of any kinds of drugs or alcohol?
no.
Well, you were on the 7th, so you probably still are, but are you
I mean,
mentally
I'm
all
sure
right?
it's still in my system, but I'm not, as of right now, I'm not, no,
Okay, you haven't used today?
no,
Okay. All right. Has anyone threatened you to make you plead guilty?
no,
Now, at the bottom of page 2, there are several lines that are amended in black and printed in black that read, bold, I should say, that read as follows. Defendant shall enter a plea of guilty to count 1 as amended and count 3 as amended. State will dismiss remaining counts. State and defense jointly recommend 24 months incarceration on count 1, consecutive to 24 months incarceration on count 3. State will not oppose judicial release to substance abuse treatment after 6 months incarceration. Defendant agrees to pay back buy money to the Highland County Task Force in the amount of $540. Defendant agrees to cooperate fully with the task force. Has anyone promised you anything other than that to get you to plead guilty here today?
no, sir,
Now, under the law, the matter of sentence is up to the judge, not to the parties. And so even though there's an agreement as to what the sentence should be, and that if you are sentenced that you be given judicial release, or at least the state's not opposing that, that's not binding on the court. The judge is the one who makes that decision, and I'll make that after all the information has been submitted to me. So, if you plead guilty, once I've heard all the information, if I decide that the evidence is such that that's not the correct sentence, I could sentence you to, it says 48 months with the judicial release. I could sentence you to 72 months with no judicial release. You understand that?
yes, sir,
Okay. You hold any license or certification from any state agency that governs any occupation or profession?
I'm sorry, what
Do you
guys-
hold any kind
No.
of professional license or certification from the state for any kind of an occupation or profession?
No,
All right. Now, you have constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel. Mr. Wagner was appointed to represent you. Now, that wasn't simply to get the case worked out, but to provide whatever defense could be available to you under the law that you would like him to provide. So if you decide you do not want to do this, that you want to defend against the charge, he'll continue to represent you, including defending you at trial, if that's what you want. Do you understand that?
yes, sir,
Right? Now, under the Constitution, you have a right to have a jury trial on these charges in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they would be instructed on the law, and that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree, as to whether the state proves your guilt. Now, if you didn't want to have jury trial, you didn't want to plead guilty, then you could waive or give up in writing your right to have a jury trial, and in that case you could have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt by proof beyond a reasonable doubt. Do you understand that?
yes, sir,
And now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. That means that witnesses have to come into this courtroom and testify in front of you and your attorney, and everyone else is present. After the prosecutor's done asking those witnesses questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
yes, sir,
Now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, the same as the state. So, if you have witnesses that you're not certain are going to come in voluntarily, you can ask for a court order, which is called a subpoena, and that forces those people to come into court to testify for you, just like the state's witnesses are forced to come into court to testify for the state. Do you understand that?
yeah,
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one can even comment about it except in one situation, and that is if there's a jury trial and you do not testify, the judge instructs the jury that because that's your privilege and constitutional right, they cannot use it against you or consider it in any way. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of the offense charged. So, what that means is that the burden of proof isn't on you to try to prove you're not guilty because you've been accused. In fact, under the law, you don't have to put on any evidence to defend yourself at all at trial. You may, but you're not required to. But whether you put on any evidence or not, the burden of proof will always remain on the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof known in the law. And again, the verdict would have to be unanimous on each case by a jury. Do you understand that?
Yes, sir.
All right. Now, you originally entered a not guilty plea to these charges as indicted, and that plea exercised or invoked all the rights I have just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. A not guilty plea denies the allegations in the indictment, denies that you've committed a crime, and it exercises or invokes all of the rights that I've just explained for you today. Oh, I'm sorry, it waives, gives up all the rights I've explained for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty, waives, gives up your right to a jury or court trial. It waives, gives up your right to confront witnesses against you and cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination because you say you're guilty. That is what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, then the state is no longer required to prove you're guilty. It waives, gives up your right to file an appeal on any alleged violations of your rights you think could have happened up until today in this case. Now, should you be sentenced to the maximum sentence on either charge or under other limited circumstances, you could file an appeal. Any appeal you'd want to file would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Also, a plea of guilty would subject you to being sentenced immediately today by the court, if that's what I decide. Do you understand that?
Yes, sir.
And are you a U.S. citizen?
Yeah.
Now, do you have any questions about the charges as amended? Do you understand the amendments and what the difference is from the currently charged case counts?
Yeah.
Do you have any questions about the penalties?
No, sir.
Do you have any questions about your constitutional rights?
No, sir.
You understand them?
Yeah.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yeah.
Do you have any questions about the plea of guilty, what it means, or what's going to happen if you plead guilty here today?
No, sir.
You understand?
Yeah.
Now, do you need to talk to Mr. Wagner about anything else before we go any further?
Do it.
Well, if you have questions.
No.
Okay, if you need to talk to him, it's all right. I don't have a problem with that.
No, that's fine.
All right. So you have any questions about anything I've explained?
No, sir.
Then it's your decision. You still want to go forward with this plea agreement even though it's been signed some time ago.
Yeah.
All right. Then as to the charge and amended in count 1, which would read that on or about August 2, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk but less than 5 times bulk, in violations of Section 2925.03A1, thus being the amended charge of aggravated trafficking of methamphetamine, a third-degree felony, carrying possible prison term between 9 and 36 months, in increments provided by law, fine of $10,000, a mandatory fine of $5,000, and a license suspension of 6 months to 5 years. How do you plead? How do you plead?
Guilty.
As to count 3, which alleges that on or about August 12, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, amount equal to or exceeding bulk amount but less than 5 times bulk amount, violation of Section 2925.03A1, also this a charge of aggravated trafficking of methamphetamine in the vicinity of a school, aggravated trafficking of methamphetamine, a third-degree felony, the same penalties as count 1. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, this cause came on before the court this 9th day of March 2023, and the court finds that the defendant in open court was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11, and therefore the pleas to counts 1 and 3 as amended are accepted or ordered filed, and defendants found guilty of the amended charge of aggravated trafficking of methamphetamine, a third-degree felony in each count. Counts 2 and 4 are dismissed. All right. I note that there is a request for pre-sentence investigation, but I'm not going to order. I'm going to order a post-sentencing investigation, not a pre-sentence. I'm going to proceed with sentencing forthwith. Anything from the state?
Only what is contained in the plea agreement, Your Honor.
Mr. Wagner?
Your Honor, we would ask the court to go along with the plea agreement, Your Honor. Again, I obviously will follow and do respect the court's ruling on no PSI. Again, I'm just on behalf of my client, he is requesting that. The family has, I believe, got him into FRS yesterday. He had an assessment set up. So if the court would like to see the results, be quiet. If the court would like to see the results of that assessment, Your Honor, giving us 30 days, may give the court that opportunity. But obviously, we do respect the court's ruling, Your Honor.
Anything you'd like to say, Mr. Deaton?
Stand up and address it.
I apologize for showing up to court messed up. It was a dumb decision, and that's all I gotta say.
Okay. Well, glad you recognize that, because it was, and that's why you're going to prison today instead of getting a PSI, because you'll just take the time to continue to get high. It's pretty clear. And quite honestly, you and your family may not agree, but this is probably the best thing for you. Because I've had people that just continue to do this and end up in the hospital or worse, or get more charges. So it won't affect my decision as to your judicial release, but I just think that, and plus what you did, so evident that the court can't allow people to do that and not hold them accountable, because other people are watching and they see people showing up, messed up and high and walking away. They're just going to say, "Oh, that judge isn't going to do anything about it," and that's not me. So it's not personal; it's just your behavior. You're not being punished because of who you are, because of your behavior. So it's the order of the court that you be and are hereby sentenced on count 1 to a term of 24 months, and on count 3 to a term of 24 months. Those sentences are ordered to be served consecutively for a total of 48 months. The court finds that consecutive sentences are part of the plea agreement. The offenses were committed as a course of conduct over a period of days. Also that the sentence being imposed is not disproportionate to the harm caused, and because and one single sentence would not adequately reflect the seriousness of the conduct, because the defendant was selling large amounts of methamphetamine in the vicinity of the school, and that is conduct as such that is necessary for the protection of the public based on this criminal history to protect it. I see the date of arrest was 12/29. We don't have a jail time credit sheet, but trying to see when he was released. You remember when you were released out of jail, Mr. Deaton, after you were arrested?
The 18th of January.
I have a bond, Your Honor, timestamp January 18th.
18th, okay. So that would be 20 days of jail time credit.
Was he held in Greenfield the first time?
Yeah, he was.
He was arrested on the 28th, Judge.
On the 28th?
Mm-hmm.
Okay. So that'd
He was
be
held in Greenfield
21 days then. Okay. Oh, the return was, yeah, okay. They arrested him and then filed the paperwork. All right. Thank you. All right. Now, Mr. Deaton, if you should have to serve the entire sentence, and at this point, I can tell you that, I'm inclined to go along with release, judicial release, unless something shows up in the report or your conduct that, makes me decide that's not the correct thing to do. But If you should not get judicial release, or if you should have judicial release at some time in the future, violate it and go back and serve the entire prison term. Upon completion of the prison term, it is possible that the Adult Parole Authority would put you under post-release control as part of this sentence, and that means you'd be supervised by a parole officer for a period of up to 2 years in the terms they set. If during that period of time they determine that you have failed to comply, then they can return you to prison for a period of up to 9 months for any single violation, but there's a cap or limit of half of your prison term, which in this case is 24 months for all violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence a judge in the new case could impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. Now, there will be no suspension of your driving privileges. And have you had any change in your financial circumstances since Mr. Wagner was appointed to represent you?
No, sir.
All right, well, then the court will find that you do not have the ability to pay the mandatory fine, and it's unlikely you will have the means to pay it in the near future, so that will be waived. All right, is there anything further from counsel?
Just the $540
Oh,
restitution.
the restitution is ordered to the Highland County Task Force in the amount of $540, and you'll have to pay that through the victim witness restitution account. And that is a substantive sentence, and you'll have to pay it, and it can't be discharged in bankruptcy. You can't work it off by serving time. Also, you're ordered to pay the court costs, and if you don't pay the court costs, or if you don't make payment arrangements with the clerk, then he can collect that through various means, including levying on bank accounts, wages, earnings, assets, commissary accounts, or other assets you may have. If that doesn't collect it, then once you are released from prison, not while you're in prison, court could order you to allow you to do community service in this county and give you credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full.
All right.
All right, is there anything else from counsel?
May I approach Your Honor with
You
the
may.
form?
All right. You're remanded to custody there, Mr. Deaton.
Okay.
All right, Mr. Armitage, you want to go on in?
Mr. Jones must still be in the mountains.
All right, case number 23 CR 15, State of Ohio versus Jeremiah Johnson. This matter was set yesterday for a video pre-trial, and Mr. Johnson was supposed to go to the probation department, I believe at 2 o'clock. Did not. He was finally tracked down at home by Mr. Arjima, and tried to log in, and after several attempts, we couldn't get any sound. He could hear us, but we couldn't hear him. No, he couldn't hear us either, because he couldn't connect the audio, but Mr. Arjima was on a call with him during the session on screen, and I told him to show up here today at 9 o'clock for the pretrial. Now, I don't see Mr. Johnson, and I'll expect a one-page book report by tomorrow afternoon, Mr. King, on Jeremiah Johnson, the mountain man.
He must still be in the mountains, Your Honor.
Yeah, since you didn't know about him. But anyway, do you have any report on Mr. Johnson?
Brought his discovery with me.
Okay. Well, I don't think Mr. Johnson was in very good shape yesterday either, so I'm going to go ahead and, because it is now 9:04, and he was told definitively by Mr. Arjima to be here. And so we'll have a capious issue for his arrest. Case will go on the inactive docket until he's picked up, which I would think would be pretty quickly, but we'll not know. So, but anything further?
Your Honor, if he would show up, I'll be back over here at 10:30.
Well, you know, we're supposed to have a bed date on the 13th,
Right.
but then he's not shown up for bed dates on 2 other occasions, so I'm not holding my breath. So, all right, thank you. All right, case number 23CR048, State of Ohio versus Alicia Dawn Mount. Present for the State's Prosecuting Attorney Collins, Assistant Prosecutor King. Present for defendant is Jacob Wagner, and you are Alicia Dawn Mount.
Yes, sir.
All right, now this, I have this jacket, I just wrote the name on because it hadn't been written in yet by the clerk, but I have a proposed bill of information and waiver of prosecution by indictment in a plea of guilty form. These documents indicate that you're going to be charged with, by a bill of information, grand theft, a 4th-degree felony, and you're going to plead guilty. Is that your understanding, Ms. Mount?
Yes, sir.
Right now, I know you're represented by counsel, and he has, I'm sure, gone over this with you, but I need to explain things on the record so it's clear that you do understand what's going on and what your rights are. Under Ohio law, no one can be held to answer, in other words, required to come into court to face a felony unless that person's case has been considered by the grand jury of the county and an indictment returned. Now, the grand jury is a group of 9 people that meet periodically, usually about once a month, to hear evidence presented to them by the prosecutor about alleged crimes, felony crimes committed in this county usually. And they do not determine whether somebody is guilty or not guilty. They simply determine if there's enough evidence there to warrant the charge going forward. And so only 7 of those 9 have to return to indict a person, a vote to indict a person. Once that occurs, then the papers are served upon that person, and then they come to court to be arraigned, in which typically most people, overwhelming majority, plead not guilty. They have an attorney appointed or employed, and then there's certain procedures that go forward called discovery and potential motions and pretrials, and then the case goes to trial unless there's a resolution of the case before that time. So none of that's happened in your case yet because you haven't been indicted by the grand jury. Now, there is a procedure by which you can give up your right to have your case considered by a grand jury and agree to be prosecuted without having a grand jury indictment. And that's what this process is. And that's called waiver of indictment. And what the waiver of indictment does is allow the prosecutor to file the charge rather than having the grand jury vote on the charge and then have it filed. It's basically no difference whatsoever in the actual document. They would both say the same charge, whatever it would be, but the difference is the indictment's voted on to indict by at least 7 of 9, whereas the information is what it's called instead of an indictment. The information is filed by the prosecutor, signed by the prosecutor or a member of the staff. So that is what is being proposed here today. Do you understand that?
Yes, sir.
Okay. Now, the charge that is proposed that you waive the indictment on is, reads that beginning on or about the period of January 1, 2019 and continuing through December 1, 2022, in Highland County, Ohio, you did with purpose to deprive the owner, John Hughes, of his property, knowingly obtain or exert control over said property, to wit, U.S. currency in the amount of $12,490, said amount being equal to or exceeding $7,500, but less than $37,500, without the consent of John Hughes, the owner or person authorized to give consent, in violation of ORC Section 2913.02A1, grand theft, a felony of the 4th degree, and against the peace and dignity of the state of Ohio. So that's the charge that is signed by Ms. Collins, or is that Mr. King?
That's
You can't
that's
read
my
it.
signature, Your Honor.
Okay, yeah, okay. I never pay much attention to that, but I just happened to see that. All right, so that is the charge that's being proposed that you would waive prosecution by indictment for.
Yes,
You understand that?
yes.
All right. When did you get a copy of this, Mr. Wagner?
We've had it for a while. Alicia, you and I went over it, what, yesterday? Or the day before last?
Day before last.
Okay.
And we've met prior to that and gone over the facts of the case.
Okay. All right. So, is your desire then to give up your right to be indicted by the grand jury and go forward on the bill of information?
Yes, sir.
All right, well, I have in front of me then a form with your name and case number, and it's titled Waiver of Prosecution by Indictment, and it reads that I, Alicia Don Mount, having been informed by the court of all my constitutional rights, my right to be prosecuted by way of indictment, being represented by J.D. Wagner, attorney at law, Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment, agree to proceed in this matter by bail of information, and it's dated 3/7/23, and I see your signature there, and I do recognize Mr. Wagner's scrawl as well. And is this your signature I'm looking at?
Yes, sir.
All right. All right, now, that then brings us to the charge, or to an arraignment. And in this case, it's indicating you're going to go ahead and plead guilty today. This is a 3-page form titled Plea of Guilty. It says you're pleading guilty to count 1. And on page 3, about a third of the way down, there's a sentence that reads, I enter this plea voluntarily, and it appears Alicia Don Mount, the best signature of probably anybody in this room right now. And is that your signature?
Yes, sir.
All right, did you sign this just a couple of days ago as well?
Yes.
All right. Now, the agreement states, well, let me back up. When you signed it, did you understand it's an agreement to plead guilty? It means there won't be a trial.
Yes, sir.
And the next step would be a sentencing.
Yes, sir.
And did Mr. Wagner explain everything to you before he signed it?
Yes, sir.
You had enough time to fully consider the matter before making the decision?
Yes, sir.
And you still want to go forward with that agreement here today?
Yes, sir.
And did you enter this plea voluntarily?
Yes, sir.
All right, now, page 1 says you're going to plead guilty to the charge. 4th degree felony states that you understand the maximum penalty could be 18 months in prison. If there was a prison term, the minimum 6 months, and there could be a fine of $5,000. You understand that?
Yes, sir.
Facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you should ever be sentenced to prison on this offense and serve a term, the law provides that the parole authority may, at their option, choose to put you under what's called post-release control supervision for a period of up to 2 years, which means you'll be supervised by a parole officer in the terms they state. If during that period of time they determine that you had failed to comply, then they could return you to prison for an additional period, in this case of up to half of your prison term for 1 or more violations. But if you committed a new felony while under post-release control, then in addition, whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year or whatever time will be left on your period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right. Now, I've already read the charge to you. You recall that?
Yes, sir.
And you understand what it is you're charged with, what the state said you did, when, where, how they alleged you did it?
Yes, sir.
And you understand the possible penalty.
Yes, sir.
And you and your attorney have talked about the charge, possible evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of the trial.
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs that interfere with your ability to understand or comprehend or speak?
No, sir.
Okay. Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, the agreement states on page 2, there's a little over 2 lines printed in bold and underlined. Defendant shall under plea of guilty to the bill of information. State defense jointly recommend community control. Defendant shall pay restitution in the amount of $12,490. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. So, if you plead guilty, once I've heard all the information that's submitted regarding the matter of sentencing, if I decide that's not the correct sentence, you could get a prison sentence and or a fine. You understand that?
Yes, sir.
Right, now you have certain constitutional right. Oh, let me ask you this. Do you hold any license or certification from any state governmental agency regulating any occupation or profession?
No, sir.
All right, now you have certain constitutional rights, which understand. Your first right is you have rights to counsel, and you did employ your own counsel. But if you were unable to pay your own attorney, the court would appoint one for you. And I want to just make sure that, for the record, you're not entering into this agreement because you're concerned you won't have enough money to pay for an attorney.
No, sir.
All right. Now, you have a right to have a jury trial on these charges in which 12 people would be selected to serve on a jury from a group of citizens that live in Highland County, summons for jury duty on your trial day. After those 12 are selected, the evidence would be presented, and then the court would instruct that jury on the law. They would then decide whether or not the state proves your guilt. Now, if you didn't want to have jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and in that case you would have what's called a court or bench trial. And in that case, then the judge would be the one who would hear the evidence, apply the law, and decide whether the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Mount, you have a right to confront the witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you would have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor was done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, same as the state. And so, if you have witnesses you're not certain are going to come in voluntarily, then at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be able to testify if you want them to, and they don't want to be here. It's the same way the state's witnesses are forced to come in and testify against you. You understand that?
Yes, sir.
All right, under the Constitution, you have a privilege against self-incrimination, which means that you can never be forced to give evidence or to testify in this case at any time by anyone. The prosecutor can't make you testify, the judge can't make you testify, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you're accused. In fact, under the law, you don't have to put on any evidence whatsoever at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, we haven't had an arraignment. This is essentially the arraignment. And so, typically at an arraignment, a person enters a plea of not guilty. A not guilty plea denies the allegations in the indictment, or in this case, the bill of information, denies you've committed any crime, and it exercises all the rights I've just described for you. Now, in this case, you're agreeing to plead guilty. The guilty plea is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the information, admits that it's a crime, that you committed that crime. And that plea gives up all of the rights that I've explained for you this morning, except your right to counsel. You always have a right to counsel no matter what your plea. But without exception, your plea of guilty gives up your right to a jury trial. It gives up your right to confront witnesses against you in open court and cross-examine them through your attorney. It gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. Waives gives up your presumption of innocence because by saying you're guilty, the state's no longer required to prove you're guilty. It does subject you to being sentenced immediately by the court if the court feels that's the right thing to do. And finally, it waives gives up your right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to a maximum sentence, or under those certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, sir.
And did you enter in this plea agreement voluntarily?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the procedure that's brought you here today in terms of waiving the grand jury indictment and agreeing to plead guilty or be prosecuted by bill of information?
No, sir.
You understand that?
Yes.
Do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
Okay, you understand it? Have any questions about the plea of guilty? Or what about your constitutional rights? You understand those?
Yes, sir.
And do you have any questions about the plea of guilty, what it means, and what will happen if you enter here today?
No, sir.
Is there anything else you need to speak to Mr. Wagner about before we go any further?
I'm good.
Then this is your agreement to, it's your decision to go forward and plead guilty according to the terms of the plea agreement that we've just gone over.
Yes, sir.
All right, then as to the charge, which alleges that in the information that on or about the period of January 1, 2019, continuing through December 1, 2022, you did with purpose to deprive the owner, John Hughes, of property, knowingly obtain or exert control over property, to wit, U.S. currency in the amount of $12,490, said amount being equal to or exceeding $7,500, but less than $37,500, without the consent of John Hughes, the owner or person authorized to give consent, violation of the Ohio Revised Code, Section 2913.02A1, grand theft, a felony of the 4th degree. How do you plead?
Guilty.
And thank you. The court finds that on this day in open court, the defendant was advised of all constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Plea is accepted and ordered filed. Defendant is found guilty of the bill of information as charged. Now you can be seated. I'm going to order a pre-sentencing report. The sentencing will be set for April 20 at 1 o'clock. Here to report to the probation department. Now, you're going to be allowed to be released on an OR bond that you'll have to sign downstairs at the clerk's office. The OR bond is your promise to appear, and if you fail to appear, then that could subject you to prosecution for an additional felony. You'll be under pretrial supervision of the probation department. You're to report to them as soon as we get done. That is at 117 East Main Street, across from the Flagway, on the other side of the street, just to pass the traffic light. And then you'll be required to report to them once a week for 4 weeks, and after that, as they determine. You'll have to pay a deposit of $116 within 30 days to secure the payment of the statutorily required fees. Then you'll be subject to random drug testing. Must provide phone numbers for home, cell, and employer. Not to have any contact with the alleged victim. Probation recommends you be evaluated for any substance abuse or mental health issues. You'll submit to that. If there's any treatment recommended, you'll engage in that treatment during the pendency of this action. And what is your address, ma'am?
1736 Narrow Gauge Road, Winchester 45697.
Winchester?
Uh-huh.
Okay. And are you employed?
I'm self-employed.
Okay. Well, you'll be under house arrest at that residence, meaning you have to be there at all times unless you're working, going to and from work, whatever your business is, medical appointments, court proceedings in this or any other case, appointments with attorney or probation officer in this or any other case, any kind of schooling, job training, etc. Other than that, you have to be there at all times, and probation will explain to you when you go down there this morning how that will work. Now, you'll also need to report to the sheriff's office to be fingerprinted and photographed and so forth. Anything?
Yes, sir, Your Honor, may I address the court?
You may?
Your Honor, just for the record in the state, obviously, they've already given us a receipt. Restitution was made this morning.
Okay.
Cashier's check.
All right.
My client has asked, Your Honor, I guess, well, I'm asking for the first part. Is she permitted to go grocery shopping, things of that nature? Now, the next one, I'm maybe pushing the envelope. She has a prepaid weekend vacation in Hocking Hills State Park. I don't know if the court would permit her to go to that.
She may.
Thank you, sir.
Mhm. And yes, you can do grocery shopping, banking, that type of thing.
Thank you.
My son's baseball game.
Just be careful. Okay, we'll get you there. When that doesn't stop.
When is that vacation?
Yep.
It is April the 4th through the 8th,
Okay.
How old's your son? How old's your son?
16th.
Does he play high school baseball? Your Honor, I'm going back to the well one last time. She has a 16-year-old son that plays
Well, it's not dry yet, but it's getting close.
He plays high school baseball. She knows she could attend his high school baseball games.
Her son?
Yeah.
Okay. And children's activities are always okay.
Thanks, sir.
All right. So, we're going to go downstairs and sign your bond. You're going to get your assignment notice from the bailiff. Downstairs to sign your bond. Probation department to get signed up for pretrial supervision. And then to the sheriff to be booked on the fingerprinted and photographed and DNA and so forth. Okay, all that this morning. All right, thank you. Johnson? You take it down, she's got to be bonded out. And she's on her way down. All right, case number 23 CR 15, State of Ohio versus Jeremiah J. Johnson. Present on behalf of the state is Prosecuting Attorney Collins and Assistant Prosecutor King. Appearing on behalf of the defendant is William Armentrout, and you're Jeremiah Johnson?
Yes, sir.
All right. The matter was set yesterday for a pre-trial, and Mr. Johnson was supposed to be at the probation department, I believe at 2 o'clock for his, to be on a Zoom. He was not. Mr. Arjima, after some efforts that we observed on the screen, was able to get a hold of Mr. Johnson, and then Johnson attempted to log in and couldn't do it after, well, that was close to 3 o'clock, and I finally said that was enough and ordered him to appear today at 9 a.m. We convened at 9:05 a.m. You weren't here, and I actually ordered a capias for you, and then my assistant came in and indicated you had called, said you were 5 minutes away, and so you did make it about 10, 12, 15 minutes late, and it's now 9:30, almost 9:30. We had another case in progress. So where do we stand on this case?
You're asking me, Your Honor. I've given him his discovery today. He understands what he's charged with. I explained to him the offer that's been made by the state of Ohio, indicated that he is willing to accept that. It's my understanding, I just heard from the probation department that there is a bed tomorrow, 10 o'clock at the counseling center.
Okay. So we're going to have him do that before the, see, this case is set for trial, I believe. isn't
No,
it?
this is the first pretrial, I think, Judge, isn't it?
Oh, it is the first pretrial, that is right. Yeah, April 10th trial, all right. Well, I noticed I've been getting regular reports from probation that he'd been testing positive, and then also that he had not shown up 2 other times for beds. So what I'm going to do is I'm going to revoke the defendant's OR bond, impose a bond of $5,000, remand him to custody. We want to make sure he gets there. And the OR will be reinstated tomorrow or whenever the bed's available. And the OR condition is that you will remain there until their case is complete. And if you walk away, which you can because it's not a jail and they're not going to stop you, then you come back to jail. And if you don't, then a warrant will be issued for you. But, you know, you've had several opportunities here, and quite honestly, you know, I hate to criticize anybody's appearance because I don't consider myself to be the greatest looking person in the world, but you look like crap. And you need help, and you've not been taking advantage of it. And I have a very high level of doubt that you'll go there tomorrow on your own since you haven't shown up 2 other times. So you're remanded to custody.
Your Honor.
Don't say anything at this point.
No,
Do you want me to talk to your
you don't
mother?
need to say anything.
Where's your mother parked at?
All right.
Out there, they're good.
Case number 22 CR 222, State of Ohio versus Dallas, James Toll. Present for the state's prosecuting attorney Collins, assistant prosecutor King, and Mr. Wagner is back. We took a recess. Is there going to be a resolution of this case?
Yes, my approach, Your Honor.
You may. All right. You can go ahead and go, officers. Thank you. Mr. Toll has been presented with a 3-page guilty form here, which indicates that you're going to withdraw your not guilty plea and plead guilty to the charge. This is a 3-page document. On page 3, there is a line about a third way down that says, I enter this plea voluntarily. And then right below that appears to be signature Dallas Toll. Is that your signature I'm looking at?
Yes, sir.
And you just signed it here this morning? Now, I know you were here at 9 o'clock, and then there's been some other stuff going on, and you have had a few minutes here to talk to Mr. Wagner, and he'd indicated you'd had some discussions before. Do you understand what's in this agreement?
Yes, sir.
You went over it with you to your satisfaction?
Yes, sir.
And you feel you've had enough time to consider this matter?
Yes, sir.
Okay, you don't feel rushed or pressured in any way into doing this?
No, sir.
Did you sign this agreement voluntarily?
Yes, sir.
And you want to go forward with it voluntarily here today?
Yes, sir.
Now, the agreement states you're going to plead guilty to the charge in the indictment, which is assault on a peace officer, 4th-degree felony. Further states that you understand the maximum penalty for that could be 18 months in prison. The minimum would be 6. There's a fine available of up to $5,000. You understand that?
Yes, sir.
You facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
Pretrial supervision.
Other than that, nothing else?
Yes, sir.
Okay. Now, if you are convicted of this offense, and if you should serve a prison term, once you complete that term, law provides adult parole authority may, at their option, put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised under the terms that they set by a parole officer, and if they determine that you have failed to comply during that period of time, then they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you fail to comply by, or if you are convicted of a new felony, then in addition to whatever sentence the judge in the new felony case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Right now, under the law, I'm not required to sentence you to prison for this offense. I can impose community control or probation. That means that instead of going to prison, you'll be put under the supervision of a probation department officer for a period of up to 5 years under terms set by the court. And if during that period of time probation felt you were not compliant, excuse me, they would file a written notice of that with the court. You'd get a copy. You would have a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control and sentence you to prison for 18 months and fine you $5,000. You understand that?
Yes, sir.
All right, now, the charge in the indictment alleges that on or about October 23, 2022 in Highland County, Ohio, he did knowingly cause or attempt to cause physical harm. Patrolman Mark Hamilton, a peace officer, as defined in ORC section 2935.01 while in the commission of his official duties, in violation of 2903.13a. So that's the charge, the assault on a peace officer with a 4th-degree felony. You understand what it is you're accused of having done in that case, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2 of the agreement, it states in bold and underlined the following language. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommend community control and substance abuse treatment. That's your understanding of the agreement.
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir.
Now, under the law, the matter of sentence is up to the judge, Mr. Toll. And so, even though there's an agreement with the state that you should get community control or probation, once I've heard all the information submitted to me, if I think that's not the correct sentence, I could end up sentencing you to prison and fining you. You understand that?
Yes, sir.
Now, you hold any license or certification from any state governmental agency for any occupation or profession?
Yes, sir.
Right, the agreement, or you have certain constitutional rights you must understand before we can accept a plea of guilty from you. First, you have right to counsel. Mr. Wagner is appointed to represent you. That's not simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So, if you do not want to do this, you just change your mind, then he'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
And under the Constitution, you have a right to have a jury trial in this matter, in which 12 people to be selected from a group of citizens that live in this county, summoned for jury duty on your trial date. After they are selected, the evidence will be presented, the judge will instruct them on the law, and then they would decide whether or not the state proves your guilt. And that verdict would have to be unanimous. All 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a subpoena, which is a court order, that forces those people that you've named to come to court to be available to testify for you, even though they don't want to do that, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio in every essential element of the offense charged. So what that means is the burden isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. Whether you do or not, the burden of proof will still be on the state. Prove your guilt by proof beyond a reasonable doubt in every essential element of the offense charged, which is the highest burden of proof that's known in the law. Do you understand that?
Yes, sir.
Now, originally you pled not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you committed that crime. And that plea waives or gives up all of the rights that I've described for you today. Well, no, let me back up. Not guilty plea denies all the allegations and exercises all of the rights. Your right to have an attorney, right to have a jury or court trial, right to confront witnesses and cross-examine in open court, the right to, or the privilege against self-incrimination, the right to use the power of the court to compel witnesses to be here for you to testify the same as the state, and your presumption of innocence. Now, if you change that plea from not guilty to guilty, that waives, first of all, it admits all the allegations in the indictment and that is a crime, and then it waives all of those rights I've just described, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But other than that, a plea of guilty will waive or give up the right to a jury or court trial, waives or gives up your right to confront witnesses against you and cross-examine in open court, waives or gives up your right to use the power of the court to compel compel witnesses to come forward to testify for you the same as the state. It waives up your privilege against self-incrimination because you say you're guilty, that's what she finds you guilty. And it waives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It does subject you to being sentenced immediately by the court if the court thinks that's the right thing to do. And finally, it gives up any right to file an appeal you think you may have had up until this point in the case. If you should be sentenced to the maximum sentence or under other limited circumstances, you could file an appeal, which would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Do you have any questions about the charge, the possible penalty?
No, sir.
You understand?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
Any questions about your constitutional rights?
No, sir.
You understand?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Is there anything you'd like to speak to the attorney about before we go any further?
No, sir.
Do you have any questions at all about anything I explained here this morning?
No, sir.
Then this is your decision to withdraw your not guilty plea and plead guilty to the charge
Yes, sir.
pursuant to this agreement. And the state has consulted with the officer, I assume?
Yes, sir, Your Honor.
All right. Then, as to the charge, which alleges that on or about October 23, 2022 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to Patrolman Mark Hamilton, a peace officer as defined in ORC Section 2935.01, while in the commission of his official duties in violation of Section 2903.13a, Ohio Revised Code, to charge of assaulting a peace officer, a fourth-degree felony, carrying possible penalty between 6 and 18 months, and fine of $5,000. How do you plead?
Guilty, Your Honor.
All right, thank you. You can be seated. All right, the court finds in this day in open court, defendant is advised of all his constitutional rights and a knowing, intelligent, voluntary waiver pursuant to criminal rule 11. The plea is accepted and ordered filed. Defendant is found guilty of the charge set forth in the indictment. The matter is referred to the probation department for a pre-sentence report, which shall include an assessment for substance use and/or mental health issues and treatment. Sentencing will be April 20 at 1 p.m. and bond is continued. Are you in any treatment at the moment?
No, sir.
All right, we go down to the probation department and report to them, tell them you've entered a plea, you need a pre-sentence report, and also talk to them about getting an assessment for your treatment.
You know, just for the record, he has spoken to Eric about it, and I think Eric has recommended alcohol, so he needs to
Okay.
look
Well,
into that.
that's under substance use.
Okay.
Generically.
Yes, sir.
Yeah. Okay. Then you're going to get an assignment notice here, then go right down to the probation department.
Yes, sir.
All right, thank you.
Thank you, Your Honor.
Was Ms. Collins able to find his
It's like
This is case number 14 TL 872, Department of Taxation versus Lena B. Coogan. You're Lena B. Coogan? All right. The state is represented by Susan Davis, attorney at law, appearing on behalf of counsel of record Mary Spaya Carducci. The matter before the court is the objection filed by Ms. Coogan to a garnishment order that she received, indicating that her only income was disability. Now, I'm reviewing this, that it looks like there had been a previous garnishment issued to an employer, but you're not working at this time?
No.
What is your disability income?
It's like 13.
No, I mean, from where? What's the source of it?
Oh, for my disability.
Yeah. Are you getting, is it Social Security or is it from your employer?
No, it's from Social Security.
Social Security disability. Okay. And when did you become a recipient of that?
2012.
Okay. So there's, okay. So have they served a garnishment on your bank or bank account? I didn't see that.
No.
So how did you get notice of, yeah, this says it went to Adena Regional Medical Center.
Yeah, I was working like 20 hours a week, and then I had quit that job.
Okay, so you're not working there anymore?
No.
All right, well then they're going to return the garnishment then unserved or unexecuted. So you've not received anything to garnish any bank account?
No.
Okay. All right. Well, based on that, I'm going to find the objections are moot because they haven't actually done that. Now, if they do, and Ms. Davis, you might want to communicate that to the counsel for the AG, because that is exempt. Your income in your bank account that is solely from disability is exempt. Now, is that a joint account or,
No, single.
and there's no other money coming into that account?
No.
All right, well, what has to happen when something like, if it should happen, because she can send it up there, but I can tell you from history, these things get, if somebody returns them back, then they send them out to someone else, you may hear from them again, is you have to show, you have to have your bank account and show the record of the deposits. We can have you redact out, you know, the confidential information, but it has to show that the only money going in there is disability. Because if you get a check from something else, if you sell some property or somebody gives you money or something and goes in there, that money is subject to garnishment if it exceeds the threshold level. So just so you know.
Yeah.
Okay.
I have a bank statement with me today.
I don't need it because they haven't levied on it. Yeah. See, the only thing here was when they went to Adena. I see that there was a garnishment back in 2020, I think, where they asked for a garnishment of other than personal wages, but that's long past. So, okay.
Gosh, Judge, when she quit, or did you quit or get fired? Or?
She 2012. You said you got disability.
So I had disability since 2012 and worked off and on like 20 hours.
When was the last time you worked?
February 12th, 2022.
Over a year.
Yeah.
Okay. All right.
Thank you.
All right. So, again, if they should garnish that account, you would need to bring in, I would say, 6 or 8 months of statements to show what that is, because it would have to show that the money that's in the account is less than what your disability is. Yeah. Okay. All right. Thank you.
All right, good, thank you.
Defendant, both State of Ohio versus Kayla Sue Valentine. You are Kayla Sue Valentine?
Yes, Your Honor.
All right, this is a hearing on a motion for judicial release filed by Ms. Valentine pro se. There are two cases, as I indicated, 20 CR 126, and in that case she was convicted of possession of heroin and sentenced to 10 months in prison on August the 3rd, 2022. In case number 20 CR 226, she was convicted of failure to appear and sentenced to, I believe, 14 months on the same date. Those were to run consecutively. The defendant did file a request for a motion for judicial release. The court did order a report to be prepared by the probation department, and I have received that. Ms. Valentine is pro se. Mr. King, assistant prosecutor, is in the courtroom representing the state. All right, Ms. Valentine, is there anything that you would like to say? I've read your motion and the report, so is there anything you would like to add?
Yes, I would. I have been doing some research through a sober living, actually through Larry. He runs the NA here, because I go every Wednesday. I got his card and stuff. It's called Nora. It's a sober living and rehab. They said that if I go there, I could be picked up, and I just need the courts to call them, because they said they had a bed date and everything for me. So I want to continue my sobriety.
Okay. Mr. King, is there anything from the state?
Thank you, Your Honor. The state is opposed to this motion. Remember that a memorandum was filed on January 26. I'll just point out a couple things. When these cases were pending, the defendant actually had a warrant for over a year. She failed to appear at a pretrial in September of 2020. Case was issued, and she was not picked up for a full year until September of 21. Pretrial was then held in November of 21. The defendant appeared, but she was not compliant with probation. Then this was set for a plea hearing in January of 22. The defendant again failed to appear. Case was issued, and she was not arrested until June of 2022. The defendant has a pattern of not appearing in court. She also has a prior conviction out of Fayette County for possession. After entering a plea of guilty, she failed to appear at her sentencing hearing in that case. And just looking at some of my notes from when we were dealing with this case, the defendant does have a warrant out of Colorado that's been in place since 2012. And I believe she's had a couple opportunities of treatment in the past. I have a note here that she's been to Foundation's residential treatment twice, most recently leaving that program in May of 2022. So based on all that, the state is opposed to the motion, Your Honor. Thank you.
What happened with your Fayette County case, Ms. Valentine?
I got sentenced to 6 months when I was 8 months pregnant.
You got sentenced to what?
6 months in prison.
All right, and
when I was 8 months.
And have you served that sentence yet, or is that consecutive to our sentence, or what?
I served it.
It's over? Okay. Yeah, I do see that there was a warrant for you out of Colorado for possession of meth in 2012, but that's 10 years ago, so they don't apparently want to come get you. Well, the state has a good point in terms of what's happening, but in reviewing your file, it appears to me that, that addiction is what was driving your conduct. And so I am going to give you a chance, but I'm not familiar with this outfit that you referred to. And we have our own plan here for people to be sober. And the choices you made in terms of your own rehab in the past haven't worked out. And so what we're going to do is I'm going to grant your motion to grant judicial release, and you're going to be placed in the Star CBCF. There's a bed available there on March the 22nd. So you'll be released on March the 21st to the custody of the sheriff and be conveyed and held in jail until you're conveyed to the Star CBCF program. Now, the conditions are that you are to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed. You're to be truthful with the officers and probation department regarding your Conditions: when they talk with you, you must report when and as directed. Keep them informed of your residence at all times and employment. Can't change either of those without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility once you're released from CBCF, nor may you communicate with anyone who is a prisoner in any of those facilities, state, local, federal, or any other, without prior permission in writing. Now, you're disqualified under the federal and state law from owning, possessing, or using a firearm, ammunition, or dangerous ordinance. It's also a condition you not use those during your community control, or any other weapons of any type. You're not permitted to purchase, possess, use, or have in your control any alcoholic beverage or any controlled substance, drug abuse, or any instrument, device, or thing that may be used to administer those or prepare them for administration. Unless you've got a lawful prescription, you have to provide a copy of that. You're not to be present in places where alcohol is being sold or consumed, even if it's otherwise lawful. You're to submit to drug testing. You're not to associate with anyone as a co-defendant in this case, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions without written permission. You may not marry or establish cohabitation in a common law type of relationship with another without written permission. You must report any contact with law enforcement on arrest, citation, conviction of the charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information so your ability to pay any fees or fines or costs can be reviewed. If you're referred for an evaluation for any further treatment or programming of any type beyond that ordered by the court, you'll submit to that. If programming is recommended, then you'll enroll in and complete that. Now, it's extremely important condition here, the single most important condition. You're to successfully complete the STAR and aftercare recommended. And that means you don't get 95% done, it means you get 100% done. And you've had some problems with completing programs in the past. STAR is a lockdown facility, and if you don't cooperate, then if they terminate you, you'll be sent back to prison, because if you can't get through the STAR program, then there's no sense in wasting any more time. And then I'm also referring the case to the drug court for you to talk with the drug court coordinator to see if you are interested in applying for that program. I don't know if you'll meet the criteria or not, but I think you will. But as far as the legal criteria, I don't know about the clinical criteria. It's a voluntary program, a docket. It's not mandatory that you do it, but they will meet with you to see if you are interested in it, because that is an extremely effective program in terms of helping people maintain sobriety once they come out of STAR. It's not 100%, but it's much higher rate than typical probation. All right, we will notify the institution, and the sheriff will be picking you up on the 21st. Do you have any questions?
No, Your Honor.
All right, thank you.
Thank you.
Yes, sir.
Okay. It's two cases before the court involving Miss Adams, 21 CR 195, 21 CR 117. And Miss Adams is appearing by video from the institution. Which institution are you in, Miss Adams?
ORW.
Okay, I'm getting audio, but I don't see any video movement. I'm wondering if I've got the right. She's not moving her mouth when I hear the audio. I'm wondering if I'm getting audio from one side and video from another. I'm looking at a screen that says,
wave your hand.
Says Jeffrey Collison. And who is that individual?
I'm waving.
That's we're in a different area of the Ohio Reformatory for Women. I have a Miss Cheney with me.
All right, well, I've not seen any response from the woman in the screen. Okay, who is this Miss Adams on the screen marked Jeffrey Colson? Raise your right hand. You are Tara Adams?
I'm Tara Adams. But you're not with Mr. Colson. Okay.
Okay.
I'm Kayla Cheney.
Okay, I can see Tara Adams now on the Jaeger screen. So that must be Miss Cheney on the Colson screen.
Going to it right now.
Yes.
Well, can I
Okay.
just tell them one of them to mute
All
their
right,
mic?
let's do Miss,
Hello.
let's do Miss
Hello,
Cheney
Your Honor.
then.
I'm sorry
Miss
to
Cheney,
interrupt.
can you hear me? Okay, so this is State of Ohio versus Kayla Cheney, 22 CR 25. And you are Kayla Cheney appearing on the screen. It's marked Jeffrey Colson.
Yes, sir.
All right. Miss Cheney was convicted in this court of 2 counts, count 25 and 26, aggravated possession of methamphetamine, 2 counts, and was sentenced to 48 months in prison on March 23rd, 2022. And she has filed her motion for judicial release, pro se. The Assistant Prosecuting Attorney, Adam King, is appearing on behalf of the state. I have read your motion, Ms. Cheney, on, as well as the report that I received from the probation department, and there is a bed available for you for a star bed on the 22nd of March. Now, is there anything you would like to say about your motion that you haven't already said in the paperwork?
No, sir. Just thank you for giving me the time today.
Oh, but your name's now Ison, isn't it?
Yes, sir.
I just saw my note here, so I'm going to put Ison on there. I don't think we ever amended the paperwork. All right. Anything, Mr. King?
State has no objection, Your Honor.
All right. All right, well, Ms. Cheney, it's the order of the court that you be granted judicial release effective March the 21st. At that time, you'll be released to the custody of the sheriff and brought back to the jail and held in the jail, and until you're conveyed to Star, which is going to be on the 22nd. You are put on community control, and your sentence is suspended, and you'll be required to comply with these conditions. You must obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, must be truthful in all statements you make to the probation department regarding your conditions, must keep them informed of your residence, place of employment at all times, may not change either without prior written permission of your supervising officer. You're not permitted to leave the state of Ohio at any time without prior written permission. You may not, once you're completed a STAR program, communicate with or attempt to communicate with or enter upon the grounds of with any inmate in any facility, and you may not enter upon the grounds of any correctional facility of any jurisdiction. You're not permitted, because of these convictions, to purchase, possess, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. To do so will subject you to federal and state prosecution for crimes. It's also a condition you should not have any of those items or any other weapons of any type while you're on community control. You may not purchase, possess, use, or have under your control any alcoholic beverage or any controlled substance, drug abuse, or instrument or device or thing may be used to administer or prepare them for administration unless you have a lawful prescription, a copy of which you must provide to your supervising officer within 24 hours. You're not to be present in places where alcoholic beverages are sold or being consumed, even if it's otherwise lawful, and you shall submit to drug testing. You're not to associate with anyone as a co-defendant in this case, or any other person who has a criminal record as a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions. That also applies to any family members that fall within that definition. You're not permitted to marry or establish cohabitation, a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information so your ability to pay any fines or costs can be reviewed. If the probation department refers you for any further evaluation or assessment for further treatment beyond that ordered by the court or programming, you're to submit to that, and if there's a recommendation of programming, you're to enroll in and complete that. You're to pay the court costs and make payment arrangements to do that. Now, you'll be required to successfully complete STAR and aftercare. And successful means 100%. It doesn't mean 90%, doesn't mean 99%, it means 100%. And if you're terminated from STAR for not complying with the conditions, or you decide you don't want to do it anymore, then once that's shown in court, that'll be a violation and you'll return to prison to serve the rest of your term. And that's the same if you violate any of the other conditions. You'll be entitled to have a hearing and an attorney, but if it's proven, then you'll be returned to prison to serve the rest of your sentence. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other properties under your control where you're found at any time by any officer of the probation department. I'm also referring your case to the drug court docket. Now, that is a voluntary program, but you'll meet with the coordinator or navigator and discuss that with them, and they'll explain that to you to see if that's something you'd be interested in doing once you get out of STAR. I think that, you know, if you meet the legal, I know you meet the legal criteria. I don't know if you'll meet the clinical criteria, but it is voluntary, but it is a much more effective program at maintaining sobriety as well as helping people get employment, get education, places to live, help with getting licenses back. There's a lot of services that are available through that program that would assist you if you decide you would like to be in it. But again, it's voluntary. All right, so we'll notify the institution, and the sheriff will pick you up on the 21st, and you'll be held until the next day, and then they'll take you to STAR then. Do you have any questions, Ms. Cheney? All right, thank you. All right, if we could get Tara Adams on the screen, please. Good afternoon, Ms. Adams. This two cases involving the same defendant, Tara L. Adams, 21 CR 195 and 21 CR 117. Case number 21 CR 195, Ms. Adams was convicted of failure to appear and sentenced to 12 months, and she was convicted in 21 CR 117, possession of heroin, and sentenced to 12 months for a total of 24 months. That was on August the 3rd. Ms. Adams filed her motion for judicial release, and I have reviewed that, as well as the report that I had prepared by the probation department. All right, now, Ms. Adams, is there anything that you would like to add to what you've stated in your memorandum and motion?
I just apologize to the court, and if I am allowed to leave, I've already got a lot of stuff set up. My sister's my power of attorney, and I haven't talked to her today. She was setting up a bed at the place that I was going to go before I got sentenced. Didn't know I was going to be sentenced. She supposedly has that set up for me to go, if that's the way the court would see it. I realize I can't go back to Bainbridge. That is, I'm asking for disaster with that route. So I'm taking another route and starting over, and hopefully you'll see it the same way and support that. Thank you.
Okay. I neglected to indicate that the assistant prosecutor, Mr. King, is also present representing the state. And Mr. King, anything from the state?
No objection, Your Honor.
All right. Well, Ms. Adams, you know, you were on track to get treatment before, but you just weren't apparently in the mind of really being ready, and didn't show up for court, and so that's why I went ahead and sent you to prison, because I wanted you to have some time to reflect on things and get stabilized, and hopefully that's happened. You seem to be much more aware of yourself and in charge of your senses and so forth today. So the court does grant your motion for judicial release. Now I'm going to send you to the STAR CBCF program first, and then there will be aftercare after that, which will be hopefully transitional housing, sober living. But that I think you need to go there too to continue the recovery of your faculties. They have a program there, cognitive thinking for a change, and it's something I think is important. So it's the order of the court that you be granted judicial release. That'll be effective on March 21st. The bed's available on March 22nd. And the suspension of your sentences will be Effective on that date, when they pick you up, the sheriff will pick you up on the 21st. They'll hold you in custody until you're delivered to STAR. You'll be required to comply, you'll be under probation or community control for 3 years. And the conditions are that you're to obey all laws of all jurisdictions and conduct yourself in law-abiding manner at all times. You're to be truthful in all statements you make to the probation department about your conditions. You must keep them informed of your residence and employment at all times. May not change either without prior permission. You must report when and as directed. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapons of any other type. And if you were to do that, that would subject you to both federal and state prosecution, as well as be a violation of these conditions. You are not to purchase, possess, use, or have under your control any alcoholic beverage or any other type of controlled substance, drug abuse, or any instrument, device, or thing may be used to administer those or prepare them for administration unless you have a lawful prescription, a copy of which must be provided within 24 hours of receipt. You're not to be present in places where alcohol is being sold or being consumed, even if it's otherwise lawful. You shall submit to drug testing as required. You're not to associate with anyone who's an inmate in any of the any correctional facility. You're not to associate with any co-defendant or any other person who has a criminal record, is a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a violation of these conditions, including any family members who fall within that definition unless you have written permission. You may not marry or establish cohabitation in a common law marriage type of relationship with another person without written permission. You must report any contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fines, fees, or costs can be reviewed. If you are referred for an evaluation or assessment for any type of treatment, therapy, counseling, training, or other educational programming beyond that ordered by the court, you're to submit to that, and if any program is recommended, you're to enroll in and follow that. You're to pay the court costs and make payment arrangements to do that. You're required to successfully complete the STAR program and aftercare. And complete successfully means 100%. It doesn't mean 90 or 95 or 99.5. It means 100. And if you violate that condition or any other conditions, you'll be notified in writing of the violation. There'll be a hearing, and if the outcome of that hearing, and you would be entitled to an attorney, if the outcome of that hearing is you fail to comply, then you'll be returned to serve the rest of your sentence. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place where you're found or under your control at any time by any officer of the probation department. Finally, I'm going to refer your case to the drug court docket, and you'll be interviewed by the director or treatment navigator to discuss the possibility of you going into that docket once you complete STAR. It's a voluntary program. I think it was being discussed with you before, or at least it had been mentioned. But it's much more intensive, and it'll be much more likelihood of success in my mind if you are eligible for it. You meet the legal criteria. Question is whether or not you'll meet the clinical criteria. But they will meet with you while you're at STAR and discuss that and to see if that's something that you're interested in applying for, and if so, be put on that. Otherwise, it'll go through the other transitional control aftercare. All right, do you have any questions?
No.
All right, thank you. All right, sorry for the delay. I had 3 judicial release hearings at the same time, and amazingly, they all went through. All right, this is case number 19 CR 107, State versus Stephen Williams. Are you Stephen Williams appearing there from the jail? You need to unmute there. You're muted. It's down in the left-hand corner. There's a little microphone with a slice through it. There you go. All right, you're Stephen Williams? Well, I didn't get it. Can you guys hear me?
Yes. Yes.
Okay, the volume, you need to turn the volume up, Mr. Williams. Okay, I'm still not hearing you. It says your volume's unmuted. Can you hear me now? I can't hear you. When he comes back in, I think I'll tell him to turn it off and reboot it. Should be a volume button on that speaker. Did he come back in the room yet? Call out to the jail and tell them we don't have any volume. We're not getting any. Oh, there he is. Well, somebody's saying they'll go get somebody else. Ben, call out there and tell them to get somebody in the room to get this thing fixed. There's somebody coming in now.
Jail is they have to reboot.
Okay, that's what I was going to tell them to do.
Yeah.
All right, all right. Well, they need to, if they're going to reboot the system, yeah, okay. I'm going to say turn off that unit too. They're rebooting. Stephen Williams, and you're Stephen Williams appearing there from the jail?
Yes, Your Honor.
All right, his attorney is Catherine Hapner. This hearing is being conducted by Zoom. She's appearing from her office, representing the state's prosecuting attorney Collins. And Ms. Hapner, you and your client both agreeable to this matter being conducted by Zoom rather than an in-person appearance in the courtroom?
We do, Your Honor.
And you're all right with that, Mr. Williams?
Yes, Your Honor.
All right, Mr. Williams was placed on community control for aggravated possession of methamphetamine, 5th-degree felony, on November 16th of 2019. There was a previous violation, and additional condition was ordered on October 22nd, 21, including extending his community control by a year. There was a notice, it was a CAPIS issued for his arrest February the 8th of 2023, and he was notified of the alleged violations on February the 21st. The rule violation alleged is Rule 2 of the original entry, as well as the supplemental Rule 2 from the October 22nd entry of 21. Ms. Hapner was appointed to represent Mr. Williams. The matter was set for an evidentiary hearing today. Ms. Hapner, do you wish to have a hearing, or will there be any admissions?
Your Honor, he will admit that he has not reported as directed, and I'm sorry, what was the other violation?
He was to complete
Yes.
another residential treatment, and he did not complete that. And then I'm sorry, the aftercare. He did complete the residential program, but not the aftercare. And then it said that they advised him that the officer on December 13th, the defendant, had not been reporting weekly as required to ACM.
We agreed to not report to ACM as required.
Okay.
And it's my understanding from the Sturgeon that he was transferred to a higher level of care. That was not through ACM.
Well, apparently his probation officer didn't know about it, and I can't imagine that she did either at the time, or she would have told Mr. Balzer. So I don't know. Do you want a hearing on this or not?
I know he'll admit.
Okay. All right. You can talk about that. All right. All right. So, Mr. Williams, the allegation is that Rule 2 from the original entry, that on or after December 13, 2022, you failed to report. Then the allegation from supplemental entry rule of 102221 is that you were to be evaluated for substance use disorder and successfully complete any recommended treatment. And the allegation is you didn't complete the aftercare because you were not reporting weekly as required as of December 13th when you were declared to be an absconder. So that's what we're talking about up to that point. Now, if something happened after that point before you're arrested, that's not what we're talking about.
Okay.
All right? Now, you understand those allegations against you?
Yes, Your Honor.
All right, and you understand you have a right to have a hearing in which the prosecutor would have to present evidence, and Ms. Hapner could cross-examine for you, and you could present any testimony on your own behalf that you would like to, or any other evidence. Now, if you are found to have committed the violation, whether you admit to it or whether we have a hearing that proves it, one of three things can happen. I can continue community control under the same conditions that currently are existing, and continue with additional conditions that I think are appropriate. We've already extended you by 1 year. We can extend you to a maximum of 5 years. Now, the periods of time when you were absconding don't count, so I don't know exactly how much time you have left, but it could be extended to a total of 5 years. Or the third and the most serious is I could revoke your community control and sentence you to prison for 12 months and fine you $2,500. You understand that?
Yes, Your Honor.
We were having a discussion while they were trying to log you in with your attorney and Ms. Collins and the probation officer. Are you still on PRC?
No, Your Honor. I actually completed PRC sometime before it started getting cold. I remember.
Right. Okay. Well, we thought that was the case, but we weren't sure. So,
yeah.
All right.
And, if I might add, I did complete.
Well, you'll be allowed to talk in a minute about that. Right now, the only question is I'm explaining your, what the rights are, because you haven't admitted anything yet. So if you get to that point, then you'll be able to speak. Okay. All right, so, you have any questions at all about the allegations?
No, Your Honor.
And do you have any questions about your rights to hearing or what might happen if you are found to have violated here today?
No, Your Honor.
And has anyone promised you anything or threatened you in any way to get you to admit to these violations?
No.
Okay. So, do you need to talk with your attorney? I didn't neglect to say at the beginning of the meeting, hearing that since you're not in court next to Ms. Hafner to talk to her, if you need to speak with her, I can put you and her into a breakout room with just the two of you would be on the screen talking. No one else would be able to see you or hear you. So do you need to have any conversation with Ms. Hafner?
I don't think so. I think we discussed everything yesterday.
Okay. And you have any questions then about anything I've explained as far as the allegations and your rights and consequences? Okay. Then do you admit to the violations?
Yes.
Okay. All right. Now, I'll hear from the state first, the probation department.
Thank you, Your Honor. I will first start with the probation department is requesting that he be continued on community control. They've got another bed for him somewhere, I believe. The state does not believe that he's amenable to community control at this point. I would note his prior criminal history and his prior failures on community control probation violations where he was given opportunity after opportunity and then violated and either served time in jail or served time in prison. He has, every time we're back, he's ready to change and get back into treatment and this and that. And at this point, it's the state's position that it's just his way of not going to prison and being held accountable. He's turned an F5 into a 4-year-long case because he can't do what he's been instructed to do. So at this point, the probation office is requesting he be continued with treatment. The state is requesting that his community control be revoked.
All right, Ms. Hafner.
Thank you, Your Honor. I have spoken with Kim Davis and Tanya Sturgill about the case. There was a place, and none of us could quite put our name on, put our name to it in Cincinnati, that the probation officer was recommending that he attend as residential. However, Ms. Sturgill indicated to me yesterday that there was a wait to get him there, but she has a bed available for him at the counseling center on Monday. She also sent me a text that says he did not need treatment. He was transferred to a higher level of care. I'm just letting you know, just in case, because earlier the judge said he left. Also, we do have reports that he did attend ACM as recent as December, but then must have relapsed around Christmas. I don't want Judge to think he's been non-compliant for longer than he has. So that's coming from...
Well, that should have gone to Mr. Bolser. I don't know why it didn't, but, yeah.
The state had no idea of any of that either.
Mm-hmm.
Yeah, that's a text I received from Ms. Sturgill at 3:47 yesterday afternoon. There it is. She does say she has a bed available for him at the counseling center on Monday, and that she's also confirmed that he could do his sober living at ACM once he finishes the residential treatment.
Okay. Mr. Williams?
All that sounds amazing to me. I made it about 18 months clean, and I lost track of my goals. My legal relapse prevention plan started falling apart. And
I don't think it was a plan. I think it was the execution.
right, well, yeah, you're absolutely right. I'm worth more than a penitentiary sentence, and I know that. To my family, to you guys, I almost could say I owe my money to this court for saving it over and over and over again. Whether that's medicine, sending me to prison or to rehab centers. But I constantly work on myself. I've been a mess, and I'd like to continue that. I'm finding things out every time I go. And I do continue to try. I want to be a good parent, and I know as of right now, I can honestly look at you and tell you I don't need to go home. I need to go back to treatment because I don't need to be around my family high on drugs, and I don't run from treatment. rec center one time, and the rest of them, I do well in the structured environment, and I will get this right. I will.
Mr. Bolser, have you had any conversations with Ms. Sturgill about this?
I'm actually filling in for Sandy Kelly, so I'm trying to do the best here.
Oh, that's not you. Okay, I got you.
I'm trying to keep track of all this here in the last 24 hours. It does look like he was at ACM in December. That's about all I can add.
Well, but when?
December of 22.
I mean, the whole time?
It was spotty, but yes, he was there.
It says he was transferred to a higher level of treatment, but that doesn't mean he was, if anything, it would seem to me he'd be reporting more than once a week. Can you get a hold of Ms. Sturgill and see if we can get her on this call? Ask her to come in your office instead of signing in.
Yes, sir.
All right, Ms. Sturgill is now on the screen, and Ms. Hapner read an email that you sent her that indicated that Mr. Williams in December 13th was in fact in treatment at a higher level, and I'm questioning, did you ever communicate that to Ms. Kelly?
It was in our file, sir. I saw that in the notes yesterday. It looked to me when I was reviewing the case that he successfully completed in May.
Right, we know that he's charged with not completing aftercare, and it said he was not reporting weekly as he was supposed to after December, as of December 13th.
He did go into aftercare, and he was compliant for a while. It looks like he had 3 misses, and then in December, he did show up again.
When?
And he tested positive for Suboxone, but we had information he might have a script. But he attended the week of December 19th through December 23rd. He was attending relapse prevention. And he is marked compliant on their progress report that was in our file here. After that, I believe, is when he went missing, and we did not have communication with him at that time.
And then after that, he was not compliant with their program.
Yes, which would have been late December, around Christmas.
Okay. All right. So, in actuality, you haven't been in any treatment then since the first of the year? Is that right, Mr. Williams?
No, I haven't.
Okay. Well, thank you, Ms. Sturgill, for getting that cleared up. All right. That's just not very good writing on the behalf of the officer, but I guess we'll have to talk about that. All right. Now, Mr. Bolser, how much time is left on his current supervision?
He started November 6th of 2019. I believe he extended him a year.
But he had some tolling also, I believe. There was a warrant for him, as I recall, back in the fall of 2021.
Yeah. Let me pull that up real quick.
Looks like. On October 13th, there was a warrant issued, so it looks like it was about a week.
Looks like November of 23, he might be expiring.
Yeah, I'm looking to see how much tolling we had here on the most recent. This warrant was issued on February 9, and I believe he was taken into custody on about the 11th. Does that sound right?
Yes.
Just a couple days? All right. So about 8 days. So that would extend him to about November 14 of 23. All right. All right. Well, Mr. Williams, I am going to give you one more chance here, but I'm going to extend your community control. I'm going to continue community control, extend it to the maximum of 5 years. You'll be required to successfully complete substance use treatment at TCC. Beds available on March 13th. You'll remain in jail until you go there. You're to complete that in aftercare. And I'm writing down now, this is your last chance. You know, you've been dragging this thing out, and you were close to being good, and you blew that up. But, you know, if your goal is just to stay out of prison, our goal isn't really for you just to stay out of prison. We want to see you stay sober. But, and I can't put you in the drug program because you don't have enough time left to make it effective. And so, you know, you're going to have to do this this way. But I'm telling you now, this is it. I've got it written in my notes, last chance. If you come back, even if it's 2 or 3 days before you expire, you know, I'm going to, you know, if you violate, and, you know, it's going to be prison. You know, I think you know, I think you can do this if you really want to, but I'm not convinced yet you want to. I think your goal's been to stay out of prison, and you've done a pretty good job with it, but then you relapsed, and you've got a history of relapse. And, you know, the question here is what's going to happen first? You go back to prison, or you go to the cemetery? You know, I hope that you don't go to the cemetery. The third choice is get sober and stay sober. And I hope that's the one. But right now, the top 2 choices are prison or dead. And you know, staying clean is running third. You can overcome that, but you have to want to do it. No one else is going to do it for you. It's going to be you. All right. Anything further from council?
No, Your Honor.
All right. We have a 2 o'clock pretrial. I think, are we using a different invitation on that one? Do you know? Okay. All right.
Who is it? It's a plea at
Rob,
Jake's house.
No, it's Robert Hawkins. We All right, you are Robert O. Hawkins III?
Yes, sir.
All right, this is case number 22 CR 195, State of Ohio versus Robert O. Hawkins III. Mr. Hawkins is appearing by Zoom from the Fayette County Jail. You're being held up there on charges relating to that county, I assume?
Yes, sir.
Okay. All right. Now, you were indicted by the grand jury in this county, Mr. Hawkins, back on, oh, wait a minute, I'm on the wrong file there. Here we go. October 4th of 2022. And the case numbers, yeah, okay. If for a charge of aggravated possession of methamphetamine, a 5th-degree felony, alleges that you committed that offense on or about April 16 in this county, and that's a 5th-degree felony. If you're convicted of that, it carries a possible prison term of 6 to 12 months, a fine of $2,500, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you. I see you did get your financial disclosure form filled out. Everything on that is correct?
Yes, sir.
All right. And is this the first time that you've been in court on this particular case, Mr. Hawkins?
Yes, Your Honor.
All right. Well, there we go.
Been incarcerated since June 5th of last year.
Okay. All right, then the court will find you're entitled to appointed counsel, and I will appoint Attorney Danielle Witt of Hillsborough, Ohio, to represent you, and I'll enter a not guilty plea on your behalf. We'll set a, okay, now, do you have any trial dates coming up in your case there where you'll, you know what?
No, already sentenced. Still June 5th, I do believe.
Okay, so you expect to be there through June?
Yeah.
Okay. All right, well, we'll set your first pretrial. We'll try to do them by Zoom, but if sometimes it's hard to coordinate with the different counties, but if we can do it by Zoom, we will, and that'll be on April the 5th, and we'll determine a time, or that week at least, the week of the 5th, to be determined. And I'll let my staff contact the jail there to see what they can arrange. We'll have a final pre-trial on April 19th. We'll do that in person. We'll return you to the county for that. And we'll set your trial date for May the 8th at 8 a.m. The bond is $2,500 plus an OR, which it doesn't mean anything since you're being held there, but should you be released up there, then you'll be brought down here and your bond can be reviewed at that time. Conditions of their bond will be on the entry. I'll notify your attorney. She comes up to Fayette County, I think every week, and does some work there at the municipal court. That's why I appointed her, and she'll be able to meet with you. You have any questions, Mr. Hawkins?
So on my work in this case?
No, $2,500 and OR. And then so you'll be brought down here and given the opportunity then to post a bond here if you get released up there in Fayette County before you're done here. Okay?
They got a work program up here. That's the reason why I want to know if I got a holder, not got to work.
Well, talk to your attorney about that, and we'll see. Are you convicted and serving your sentence? Is that what you're doing?
I'm serving my sentence.
Oh, okay. All right. Well, then I'll make it the OR only, because I don't want to mess that up for you.
Thank you.
But once you get released, then you report to the Hiney County Probation Department at 117 East Main Street. You report immediately upon your release from custody, if that should happen before your trial date. or before the case is complete. And then you'll be required to report to them weekly for 4 weeks. And after that, as they determine, undergo run drug testing, provide phone numbers for home, cell, and employer, and if necessary, be evaluated for treatment, and if any treatment's indicated, enroll in and follow that. And what's your residence? You're there in Washington Courthouse?
Yes, sir.
Okay, all right. So, all right. Well, like I said, my office will be in touch with the jail there in a couple of weeks to try to set up a date for a video. We got to coordinate with the attorney as well as the prosecutor's office. Any other questions, Mr. Hawkins?
This is Greenfield, right?
I don't know. It doesn't tell me. It just tells me what the charge is. Yeah.
All right.
Okay? Thank you.
All right, thank you.
Mm-hmm. All right, it's case number 22 CR 211, State of Ohio versus James C. Howes. Is it Howes or House? House. Mr. Howes is appearing by Zoom from the jail. His attorney is Catherine Hapner, appearing from her office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. Now, Ms. Hapner, you and your client both in agreement this matter can be conducted by Zoom rather than him being brought to the courtroom for an actual appearance?
Yes, Your Honor.
Are you all right with that, Mr. Howes?
Yes.
All right. Mr. Howes is charged in a 4-count indictment: grand theft, receiving, possessing criminal tools, and aggravated possession of a fentanyl-related compound. And I know we have a trial date, looks like March 23rd. I received a form here, Mr. Howes, that says you're going to plead guilty. This is a 3-page form that the prosecutor's office prepared. It says you're going to plead guilty to count 1 and 2. I'm going to hold that up to the screen and show you the front of that document, and you recognize that has your name there and plea of guilty and the 2 charges?
Yes.
All right, on page 3, there are signature lines, and about halfway down that page, there's a sentence that reads, "I enter this plea voluntarily," and below that, there's a line under which is printed signature of defendant, and I'm going to hold that up to the screen and ask if that is your signature there next to my finger.
Yes.
When did you sign this agreement, Mr. Howes?
Yesterday.
And before you signed it, did your attorney go over it with you and explain everything to you and answer any questions you had?
Yes, absolutely.
Did you understand when you signed it that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing?
Yes, sir.
Did you have enough time to fully consider that matter before making the decision to sign this document?
Yes, sir.
And after having a day to think about it, do you still wish to go forward with this agreement?
Yes.
And did you enter into this agreement to plead guilty voluntarily?
Yes.
All right, now the agreement states on page 1 you're going to plead guilty to counts 1 and 2. Count 1 being grand theft of a motor vehicle under 2903.02A1 of the revised code, a 4th-degree felony. Count 2 being receiving stolen property under 2913.51 of the revised code, a 4th-degree felony as well. States that you understand that the maximum prison term for each of those offenses could be 18 months. The minimum of the prison terms imposed on each is 6 months. There is also a fine of $5,000. If you were to receive the maximum sentence on both charges, that means the maximum penalty would be 36 months in prison and $10,000 fine. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
Not that I'm aware of.
Are you currently on probation, community control, parole, or post-release control for a felony?
Yes.
And what is that?
I believe I'm on PRC.
Okay.
It was filed November 10th, Judge.
Okay. November 10th. Yep, here it is. Okay, according to the filing on November the 10th, you had 958 days as of November 8th. So, 22 days in November. December has 31. January has 31, February has 28. Today is the 9th. 7, 10, 12. All right, if my lawyer math is correct, and it's not always, but I have 121 days. I think this one is correct. 53, and 31 is 84, 92, 102, 110, 112, 3, 4, 12. 7, 9. Nope, I was wrong. 111 days. All right, so that means there would be a balance of 847 days of PRC time. 747 days. Yeah, 111. Okay.
847 was right.
Oh, yeah, 847. Yep. That's the trouble with computers and calculators. Forget how to do math. All right, so 847 days. Does that sound right, Ms. Hapner?
It does, Your Honor.
All right. So that means that if you're convicted of this offenses and sentenced to prison, on top of whatever sentence you get, which could be a maximum of 36 months, you could also get an additional 847 days because the law says if you commit a new felony while under PRC, then the judge can sentence you for that to an additional period of a year, whatever time's left on the time, whichever is greater. And if that occurs, that has to be served consecutively to whatever sentence is imposed for the two offenses. You understand that?
Yeah.
Okay. Now, under the law, if you're convicted of these offenses, once your sentence is complete, you may be put under post-release control by the APA. It's optional. It's not required, it's optional. If, in the other case, it was mandatory. So if they do, then as you know, you'll be supervised by a parole officer in the terms they set, and if during that period of time they determine that you failed to comply, they can return you to prison for having violated those conditions for as much as 9 months for one violation, up to a limit or cap of half of your prison term for all violations. But if you're convicted of a new felony, then as we're talking about here, you could be sentenced for committing that new offense while under post-release control in this case to a period of 1 year, whatever time is left on the period of post-release control, whichever is greater. And if that occurs, it has to be served consecutively the sentence in the new case. You understand that?
Yeah.
All right, now, it's not mandatory to be sentenced to prison for these offenses. Community control is permitted under the law. So instead of being sent to prison, you could be put under community control for a period of up to 5 years under terms set by the court. If during that period of time the probation department felt that you're not complying, then they would file a written notice of that with the court, serve a copy on you. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison for the 36 months and fine you the $10,000. You understand that?
Yes.
All right, now count 1 alleges that on or about August 22, 2022 in Highland County, Ohio, you and a Miriam Ruth Vanderpool did with purpose to deprive Melinda Wilson, the owner of property, knowingly obtain or exert control over said property to wit a 2002 Chevy Blazer, property being a motor vehicle is defined in ORC 4501.01 without the consent of Melinda Wilson, owner, person authorized to give consent, in violation of section 2913.02A1. Count 2 alleges that on or about that same date in Highland County, Ohio, that you and Miss Vanderpool did receive, retain, or dispose of a certain property being a 2008 Dodge Caliber, property of Susan Sanford, knowing or having reasonable cause to believe it had been obtained through the commission of a theft offense in violation of section 2913.51 of the Ohio Revised Code. So both of those are the fourth-degree felonies with the penalties I've described. Now, Mr. Howells, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes.
And have you discussed the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, possible outcomes of a trial with your attorney? Have you discussed it? Okay. And are you satisfied with their advice and competence?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty?
No.
Now, there's 3 sentences, a little over 3 sentences printed in bold and underlined on page 2. They read as follows. Defendant shall enter plea of guilty to count 1 and count 2. State will dismiss remaining counts. So as to you, that would be 3 and 4. State and joint and defense jointly recommend 9 months incarceration on count 1, consecutive to 9 months incarceration on count 2. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes.
And does anyone promise you anything other than that to get you to plead guilty here today?
No.
Do we have a number on restitution on these cases?
We do, and it's just to one victim, Susan Sanford, $531.
Okay, and you're stipulating that, Ms. Hapner?
Yeah, my understanding is that that would be joint several between the defendants.
Yes, it would be.
That's correct.
Yeah. All right. So that's part of the agreement, the restitution, and that would be a separate sentence that would have to be paid. Serving time doesn't get rid of it, and you can't work it off, okay?
Okay.
All right. Now, under the law, Mr. Howells, the recommendation of the parties as to sentencing is not binding on the judge, because the judge is the one who has that responsibility under the law. And so there's a recommendation that you receive a total of 18 months incarceration, but once I've heard all the information, if I decide that's not the correct sentence, I could impose whatever sentence between 6 and 36 months I think is appropriate, fine you up to $10,000. And also impose the PRC time of 847 days on top of the sentence that you receive on the other counts, or on the 2 counts. Do you understand that?
Yes.
All right. Do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
Yes, sir.
Right, and you have constitutional rights, you must understand, before I can accept this plea. First, you have a right to counsel. Ms. Hapner is appointed to represent you, not simply to work the case out, but to provide any representation and defense to you that she's permitted to do under the law that you would like her to do. So, if you decide you do not want to plead guilty to these charges, that you would rather defend against them, you'll continue to be represented by Ms. Hapner. She'll defend you, including a trial, if that's what you want. You understand that?
Yes.
All right, now, under the law, you have a right to have a jury trial on these charges in which 12 people would be selected from a group of Highland County residents that are summoned for jury duty on your trial day. After those 12 are selected, the evidence would be presented, they'd be instructed on the law. And that jury would have to decide by unanimous verdict, meaning all 12 would have to agree as to a verdict on each count as to whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. You understand that?
Yes.
And under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. And that must be done in open court. What that means is the witnesses against you have to come into court, testify in public, in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Right? And under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's a subpoena, and that forces those people to come to court to be available to testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you do decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider that for any purpose. Do you understand that?
Yes.
All right, now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of each offense. So what that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is upon the state to prove that you are. In fact, at trial, you don't have to put on any evidence at all. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt, which is the highest on every element of each offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that's the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, and admits that you committed those 2 crimes in the first 2 counts. And that plea would waive or give up all of the rights I've described for you today, except your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront witnesses and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, then the state doesn't have to prove you're guilty, and that's what's used to prove you're guilty. So it waives both your privilege against self-incrimination and your right to require the state to prove your guilt. It subjects you to being sentenced immediately by the court, which is what's likely to happen. And finally, it waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence under the certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And has the state consulted with the victims of each of these offenses and informed them of these proceedings?
Yes, Your Honor, we have.
Okay. All right. Now, I didn't say this at the beginning, Mr. Howes, but since you're not in courtroom sitting next to your attorney, if you need to talk with her, I can put the two of you into a breakout room where you can talk to her. The deputy will leave the room, and no one else will be able to see you or hear you. Do you need to talk with her?
Maybe just momentarily.
All right. I'll click on a...
Before that, Judge, on his discovery, I just want to make it clear for the record, on his discovery, it said that there was a Pickaway County case that was still pending. So I just had Mr. King pull it up. He has a habeas for his arrest from there, so he does have a felony charge pending.
Oh, okay.
He did not show up for a plea hearing a year ago, is what it says on the docket.
Well, then, if you should you be convicted in that county could order the sentences to be served consecutively to any sentence out of this court. You understand that?
Yes.
Okay. All right, I'm going to open this room. There should be a button show up that says click on join, and then once you're done, click leave, and then you'll have to click to rejoin the meeting after that. Well, he beat Catherine there. Watched a movie the other day that was made in 1938, before I was born. So, okay, we're back on record. We've been talking about old movies while you were talking there, Mr. House. All right, Then are we ready to go ahead and go forward?
Yes, sir.
Yes, sir.
Okay. Now, you have any questions at all now about what we've talked about here today, what the agreement is, or what the consequences of your plea is, and that, or anything of that nature?
No, sir.
Okay. And I think I asked you, but I'll ask you again. You are a U.S. citizen?
Yes, sir.
All right. Then is it your decision, Mr. Howes, to withdraw your not guilty plea to counts 1 and 2 and plead guilty to those pursuant to the terms of the written plea agreement we've just been over?
Yes, sir.
All right. Then as to count 1, which alleges that on or about August 22nd, 2022 in this county, that you and Miriam Ruth Vanderpool did with purpose to deprive Melinda Wilson, the owner of property, knowingly obtain or exert control over said property, to wit a 2002 Chevy Blazer, property being a motor vehicle is defined in ORC 4501.01 without the consent of Melinda Wilson, the owner or person authorized to give consent, in violation of section 2913.02A1, the charge of grand theft of motor vehicle, 4th degree felony, carrying a possible prison term between 6 and 18 months, a fine of $5,000, and the imposition of PRC time of 847 days consecutive. How do you plead?
Guilty.
To count 2, which alleges on or about August 22, 2022 in Highland County, Ohio, that you and Miriam Ruth Vanderpool did receive, retain, or dispose of certain property being a 2008 Dodge Caliber, the property of Susan Sanford, knowing or having reasonable cause to believe the property been obtained in the commission of a theft offense in violation of section 2913.51 of the Ohio Revised Code, the charge of receiving stolen property, also a felony of the 4th degree with the same penalties as count 1. How do you plead?
Guilty.
All right, the court finds that on this day in open court, defendant was advised of all of his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas accepted and ordered filed. Defendant is found guilty of counts 1 and 2. Counts 3 and 4 are dismissed. Based upon the defendant's record as well as the agreement of the parties, the court doesn't feel that it's necessary to order a pre-sentence report, and I'll go ahead and proceed with sentencing forthwith. Anything from the state?
Only what's contained within the plea agreement, Your Honor.
What's happening?
Your Honor, we would ask that you follow the plea agreement of the parties. We would also ask that you not impose the PRC time.
All right, Mr. Howes, anything you'd like to say?
I just want to make it clear, like, Salisbury, BS, let you know after this, I'm planning on getting myself together, man. I've been locked up already 7 months, and, I'm too old for this, and,
Jail time credit, Ben.
I'm just trying to get this over with, so please, 9-6, let's get this over with. Thank you very much, guys.
All right. According to the sheriff, you were... This isn't right, Ben. This is as of 2/1. When were you brought back to Highland County, Mr. Howes?
I've been here since, February 27th.
Okay. And what were serving in Ross County? Was that a misdemeanor?
Yes, sir.
Okay. And you're not being held on anything else in Highland County Jail?
No, sir.
All right. They had you as being in jail for only 3 days back in December 13th and January the 2nd to the 3rd. But you've been here since the 27th. This is an older form. So that would be 1 day in February. And today is 9, so it'd be 10 additional days. So that's 13 days. Okay. Mr. Howes, it's a judgment order of the court that you be sentenced on count 1 to a term of 9 months at the Correctional Reception Center in Orion, Ohio, and on count 2 to a term of 9 months to the same facility. Those sentences are to be served consecutively one another. The court finds that the parties agreed to consecutive sentences. The court finds that the defendant has committed a series of crimes and that one single series of course of misconduct, and that one single sentence will not adequately reflect the seriousness of the offenses, and the sentence being imposed, which is a halfway sentence in each case, each count, is not disproportionate to the harm caused. The court also finds the defendant's criminal history demonstrates that it's necessary for the protection of the public. He's had convictions out of Pike County, case pending in Pickaway County and then these offenses. The court also orders that the defendant be ordered to serve the 847 days of PRC time since these offenses were committed while under PRC. Now, one thing I try to make clear to everybody, Mr. Howes, is, people put on PRC, they got a lot hanging over their head, and if they can't stop themselves from committing crimes, then they're going to pay the price. So I always impose it. So that's 847 days consecutive to the 18 months. According to the sheriff, you have 13 days credit, which you'll be granted. Now, upon completion of this sentence, it is possible that the Adult Parole Authority may put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set. If they determine that you have not complied, they can return you to prison, make you serve an additional period of up to 9 months for a single violation, up to half the prison term for all violations. But if you commit a new felony, as in this case, then in addition to whatever sentence a judge in that new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control to an additional period of a year, or whatever time's left on that period of post-release control, whichever is greater, which if that occurs must be served consecutively. It's also ordered you pay restitution in the amount of, was that $527? $531 to Susan Sanford. That'll be ordered to be paid jointly and severally with your co-defendant. That payment is to be made through the Highland County Victim Restitution Account, and you'll pay any service fees attached to that for that service, and that is not something that can go away. You got to pay it, and even if you serve your entire term, it'll still have to be paid. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. And if you don't make payment arrangements, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you can do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right. Are there any other matters that will be brought before the court by counsel?
No.
All right. You're remanded to custody to be conveyed to the institution, Mr. Howells. Thank you.